This intense courtroom video captures two emotional and unforgettable cases where Judge Boyd delivers powerful decisions that leave everyone paying close attention. In the first case, a frustrated defendant stands before the court, clearly upset with his attorney and blaming him for receiving a 1-year jail sentence. He feels he deserved a better outcome, but Judge Boyd quickly steps in and sets the record straight. She explains that considering his criminal history, the sentence he received was actually far more lenient than what he could have faced. The judge firmly reminds him that his situation is the result of his own repeated choices, not his attorney's actions, and calls out his lack of accountability and respect. The tension continues in the second case, where another defendant faces serious aggravated robbery charges. His wife takes the stand and speaks on his behalf, hoping the court will show mercy and give him another chance. The courtroom becomes silent as Judge Boyd reviews his past, including substance abuse and violent behavior. Despite the emotional testimony and requests for leniency, the judge makes a strong and decisive ruling, sentencing him to 10 years in prison. This video shows the true reality of courtroom justice, where emotions run high, excuses are challenged, and Judge Boyd delivers firm decisions that highlight the importance of responsibility, consequences, and facing the truth.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? You can unfold your arms. Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
So to say.
I'm sorry?
So to say.
I'm sorry, what?
So to say, yeah, a little bit.
Okay, I don't understand the first. No. All right. Do you want a jury trial?
No.
Because we'll give you one.
Sure don't.
So again, we're back to the question, are you satisfied with the way you've been represented? All right, the court will find that defendant has, I'm sorry, now are you a U.S. citizen?
Yes, ma'am.
All right, the court is finding there's sufficient evidence to find you guilty and the court is finding you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, is there anything you wish to say on behalf of your client?
Your Honor, I would just like to make a brief record, if I may.
Yes.
I just want, for the record, to state to the court that I had discussed this case at length with my client. We met while he was out of custody and went over all of the police report, 911 call, videos, etc. I negotiated the plea to waive 2 previous convictions that he had when he had gone to TDC previously. And while I believe that I've done a great job, I did explain very clearly to him that if he was not satisfied with the plea bargain offers, that he certainly could go to trial. He has, as the court's seen, agreed that he wants to take advantage of that plea bargain offer, and I would ask the court to go ahead and follow that and allow him to go ahead and serve the 1-year state jail. But I want to make very clear, and it always concerns me when somebody insinuates that I didn't do my best or didn't do a good job, because you know how hard we work. I know how hard I work. And I just want to make clear that I did everything that I could for this young man standing here before you. And I am asking you to please go ahead and follow that.
All right. And so with his prior trips to prison, then is that something, because I don't have that before me, is that something that would have made this enhanceable?
Correct.
And
to
with
the second-degree felony.
2 to 20 years.
Correct.
Now, Mr. Ramirez, what I can tell you is I've read the police report. And honestly, from reading that, there's so much that could have went wrong. So the fact that you all have agreed to 1 year is to your benefit.
Yes, ma'am. I realize that. Because
more is deserved. And what I can tell you, if the state would have offered 15 years and went forward on the enhancements, I would have said, yeah, 15 years, that's about right. So you're lucky that your attorney was able to negotiate for you and only get 1 year for somebody who's been to prison on an offense that could be enhanced to a second degree.
Yes, ma'am, I know. I'm blessed. I'm sure she's a wonderful attorney.
Well, then why all this hesitation and this, I don't know, attitude about
It just,
Yeah, I think she's okay or whatever you're saying.
I mean, no, it goes deeper than what it is. I'm saying, I mean, I have a 4, 8, and a 12-year-old, and I've just gone through emotional stuff personally, but I don't mean no disrespect to my attorney.
Well, the fact that you have a 4, 8, and 12-year-old and you're going to prison and you've obviously been in and out of prison while you had those 4, 8, and 12-year-olds on the planet, that's your fault.
Yeah, I know that.
These are bad choices that you are making.
I already know that.
And so if you want to be in your children's life, that is not your attorney's fault. That's all on you
Yeah,
for not doing what you're supposed to do.
I'm
You're not stepping up to the plate and being a father they can look up to.
I know that.
And this whole thing, this whole police report where you're chasing somebody in a vehicle, guess what? When somebody doesn't want you anymore, they don't want you anymore. Relationship is over. Move on. And all of these relationships that people are in,
Somebody that he had, this
I
was
know.
a stranger.
I know, but all of these relationships that people are in with spouses, with girlfriends, with boyfriends, you have known your parents longer than you've known these people. These people come into your life for a year or 2 years and you act like you can't live without them. So here's the thing. You have children on the planet. If you're not going to be a good father to them, if you're going to be in and out of the prison, it's probably best that you cut them loose so that perhaps they can have a good start in life without you in it and bringing nonsense. I'm going to follow your agreement. I'm going to sentence you to 1 year in the state jail facility, give you credit for any time served. And I was tempted not to give you any credit, which I could do for that.
Did check, Judge, and he has calendar days, 191 days. And I'm so sorry to derail you, but
No.
it does, I take it personally when somebody acts like I didn't do my best, and I just.
And the
wanna
court
make
is
sure that
aware of your work,
Thank you.
and the court appreciates your work.
I appreciate that.
And she also speaks Spanish. And Jason, I appreciate your work too. I don't want people to say I'm unfair.
I worked with Jason today, but I'll appreciate him later.
All right. It's there. I appreciate Jason Garhan. I appreciate Kathy Compton. I feel like Romper Room. I know I'm aging myself with Romper Room where she would look through the mirror. And Michael Villarreal, I appreciate you as well. Thank you. And everyone else who's in the room. All right, Mr. Ramirez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Do better, okay? I'm sorry, Mike Christopher Pettis. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Orlando Castagnone for defense.
And are you Mike Pettis?
Yes, Your Honor.
All right, you entered a plea of guilty in both of these cause numbers on December 16th. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you've applied for deferred adjudication. According to the plea bargain agreement, punishments be assessed at 10 years in the prison, and the state is opposing your applications in each cause numbers. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Are there any witnesses from either party?
I have one witness, Judge.
All right, defense, call your witness.
We call her.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand. State your name for the record, please. Virginia Rodriguez. All right, defense.
Yes, Judge. Virginia, how are you acquainted with, how long have y'all been together?
11 years.
And do y'all have any children together?
Yes.
Okay. How old is he?
25.
How old are you?
30.
Okay. And y'all have 4 children together?
3.
3 children. Okay. What are their ages? Okay. Now, when the time of this 2 charges occurred, what was going on? Was he living with you at that time?
No.
Okay, what happened?
We separated. Job.
He lost his job. What was his work history like?
He was doing good. He was a chef at Faisan's on the Riverwalk.
Okay. Before he lost his job? Okay. Is he a good worker? When he's not under the influence of substances, what is he like?
He's a good dad. He's a good son.
Okay. In his home life, he also has, I guess, disabled parents. Is that right?
His mom's on dialysis. And when he was out, he was helping her.
Okay. Now you said he lost his job at the time this occurred, right? Was he abusing some substances?
I believe he was on pills.
You believe he was on pills? Or you're not sure exactly why? You know something was different. Okay. Now, you kicked him out of the house, is that right? And when you kicked him out of the house, what happened?
He was doing his own thing.
All right, I'm sorry, you're gonna need to speak up loudly so the court reporter can hear.
He was doing his own thing.
Okay. When you say he was doing his own thing, did he kind of spiral downhill?
Yeah.
Describe that to me.
No,
And so when you found out that this happened, how did you react?
I was in shock because it's not out of his character.
It's out of his character to do that. Okay. You were surprised?
Yes.
Did you expect him to do something like that?
No.
Okay. Has he ever been to the penitentiary before?
Yeah.
If he were to be granted probation, you think he would be successful in completing that?
Yes.
Why is that? We had responsibilities before this, right?
Yes.
What's going to be different?
As a newborn child, his mom has not, her health is not as good as it was before.
Do you believe that this has been an eye opener for him?
Yes.
Do you believe that he would benefit from some type of substance abuse treatment?
Yes. He was.
Is he motivated to do that?
Yes.
How do you
The
know?
conversations we've had.
So he's motivated for health. Okay. Now, again, if he were to be released on probation, he would not be living with you.
No,
He would be living with you.
his parents.
Okay. And his parents are his mother and his stepfather, correct?
Correct.
And they're both ailing.
Yes.
And the father has Lou Gehrig's disease. Right?
Yes.
Okay. So he would be providing for both of them. Do you live nearby?
I do.
And so would you be able to offer him support?
Yes.
Make sure he's on path?
Yes.
The pass the witness should.
State?
No question, sir.
All right, I have a question. Are you the same person who's the complainant in the assault family violence case or no?
I'm
The
not.
complainant in that case?
I'm not aware. That was a case, I believe it was dismissed.
No, I'm talking about the one, what I'm looking at on his history. I'm talking about the one where he received probation for 2016. Were you with him in 2016?
You need to speak up.
Yes.
Are you the person who was the complainant in this assault bodily injury merit case? And then in 2020, there's a violation of bond and protective order. I showed that it was dismissed, convicted of other. Was that related to you? All right. Any other questions?
No, Judge.
Anything else?
The only other thing is there was an assault family second offense that was back in 2020. Where was that you? Were you the complainant?
Yes.
No further questions on the stand.
All right. Thank you. Any other witnesses from either side?
No, Judge.
All right, Mr. Pettis, you can step in this time. All right, the court will hear argument.
Judge, both of these cases are very serious. It's two aggravated robberies that occurred, I believe, on the same day, pretty much back to back. We put both victims in hell for their life, affected both of them greatly. According to the PSI, both of them have explained that they experience anxiety now, that it's how they are at work, and it's an experience that they've never had before. We understand that there may be substance abuse issues here, but at the same time, the defendant, through his actions, put several members of the community in jeopardy. And we believe that PDP would be appropriate here.
All right, defense.
Yes, Judge. So we're asking that he be placed on deferred adjudication. He would be subject to the full range of punishment, 5 to 99. He's not been in the penitentiary before. I believe this is an eye opener. I believe that also substance abuse treatment would be appropriate, and that would continue his incarceration, which he has been in custody since this offense. At the time that this offense was committed, he was under the influence of Xanax and had been consuming alcohol. I believe that this opportunity would be good for society, and that it would allow him to show the court and the world that he's able to be a good, productive member of society. And if not, on the first violation, Judge, you would have the ability to sentence him to the full range of punishment.
All right. Mr. Pettis, is there anything you wish to say? All right. The court will deny your application in each cause number. The court will find you guilty in each cause number. In each cause number, the court will sentence you to 10 years in the prison. There's affirmative finding of deadly weapon in each cause number. The court will give you credit for any time served. Each case is to run concurrently, and the court will take in consideration 2022 CR 7825. Did you review with your attorney the document entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers, and did you sign it? because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand, Commissioner? All right, we can go off the record. Mr. Pettis, I did listen to everything that was presented to me, and I understand the issues with your parents, but sometimes, you know, our actions are our actions and there are consequences for it. So I hope everything works out with your father. I hope everything works out with your mother. This is not the end of your life. Hopefully, when you go to prison, you will internalize, learn things, take care of any issues that you may have. And when you are released from prison, if you need rehab, there are plenty of rehab places that are free. Get into some sober support meetings and do the right thing, okay?
Today's courtroom drama unfolds with a level of tension you can feel through the screen. Judge Boyd walks in with calm authority, and from the very beginning it's clear that this is not going to be an ordinary hearing. Two very different defendants. Two very different stories. But one consistent theme: accountability. The first man steps forward already frustrated. His body language says everything: arms tight, jaw set, clearly upset about how things turned out. He's facing jail time after being accused of following a stranger in his car, a situation that escalated into criminal charges. Instead of focusing on his own behavior, though, he turns his frustration toward his attorney. He believes he deserved a better deal. He believes his lawyer failed him. And he's not shy about saying it. Judge Boyd listens carefully, allowing him just enough space to speak. But when she responds, the entire tone of the courtroom shifts. She makes it very clear that the 1-year jail sentence he received was not some unfair punishment. In fact, considering his prior prison record, it could have been much worse. Much worse. She explains that the court reviewed his criminal history, his repeated run-ins with the law, and the seriousness of the conduct in this case. A 1-year sentence was not a loss, it was a benefit. The defendant tries to push back, but the judge does not allow the blame shifting to continue. She reminds him that attorneys negotiate within the boundaries created by their clients' actions. You cannot expect extraordinary mercy when your record shows repeated poor decisions. Her words are firm but controlled. She's not yelling. She doesn't need to. The authority in her voice carries more weight than any raised tone ever could. Then she addresses something deeper: respect. She calls out his attitude toward his own lawyer, pointing out that disrespecting the very person trying to help you is not only unproductive, it shows a lack of maturity. The courtroom grows quiet as she shifts the focus from legal technicalities to personal responsibility. She talks about accountability, about the pattern of choices that brought him here, and about how continuing to blame others will only keep him trapped in the same cycle. And then she goes even further. She speaks about his role outside the courtroom. She mentions his repeated incarcerations and what that means for his family. For his children. She highlights that every time he makes a reckless decision, it's not just his freedom at risk, it's stability for the people who depend on him. That moment lands heavily. It's no longer just about a sentence. It's about a life pattern that needs to change. The defendant's frustration slowly fades into silence. There's nothing left to argue. The reality has been spoken clearly. 1 year in jail stands as the consequence, and Judge Boyd makes it clear that if he does not change course, the next sentence could be significantly longer. As the first case concludes, the atmosphere doesn't lighten. If anything, it grows heavier. The second defendant, Michael Christopher Pettis, now stands before the court facing 2 aggravated robbery charges. These are serious felonies with life-altering consequences. The gravity of the situation is visible in the courtroom. His wife, Virginia Rodriguez, steps forward to testify on his behalf. Her voice carries emotion, loyalty, and hope. She speaks about his potential. She asks for mercy. She wants the court to see the man she believes he can become, not just the man reflected in his record. Judge Boyd listens patiently. She allows the testimony. She acknowledges the emotional weight of a spouse standing up for her husband. But as the hearing continues, more details come to light. There is a history of substance abuse. There is a documented pattern of domestic violence. There are prior incidents that show this is not an isolated mistake but part of a larger behavioral issue. The defense requests deferred adjudication, essentially asking the court to give him another chance outside of prison. They argue for rehabilitation over incarceration. They emphasize support systems, treatment options, and the possibility of change. But Judge Boyd must weigh more than hope. She must weigh public safety. She must weigh past behavior. She must weigh the seriousness of aggravated robbery, crimes that involve fear, harm, and risk to innocent people. The courtroom grows still as she prepares to announce her decision. You can almost feel everyone holding their breath. When she speaks, her tone is steady and deliberate. She denies the request for deferred adjudication. She explains that the pattern of behavior, the violent history, and the seriousness of the charges make it clear that prison time is appropriate. She sentences him to 10 years for each aggravated robbery charge, to run concurrently. 10 years. The words settle over the courtroom with undeniable weight. His wife, who had just asked for mercy, now faces the reality of a decade apart. The defendant stands silent, absorbing the magnitude of what has just happened. But even in delivering the sentence, Judge Boyd does not speak with cruelty. She expresses hope that he will use his time in prison productively. She mentions reflection. She mentions rehabilitation. She makes it clear that while the court must impose consequences, the future is still in his hands. What he does with those 10 years is up to him. What makes this entire hearing so powerful is not just the length of the sentences, it's the consistency of the judge's message. In both cases, the core issue is the same: repeated choices lead to repeated consequences. Blaming attorneys, blaming circumstances, leaning on emotional testimony. None of it outweighs a documented pattern of behavior. Judge Boyd demonstrates a balance that defines effective courtroom leadership. She listens. She allows people to speak. She acknowledges emotion. But she does not allow emotion to override responsibility. Her rulings reflect not anger, but principle. The first defendant learns that disrespect and denial will not reduce a sentence. The second learns that promises of change must be backed by action, not just words. Both leave the courtroom facing time behind bars, and both are reminded that the justice system ultimately responds to patterns, not excuses. By the end of these hearings, one thing is undeniable: accountability is not optional. In this courtroom, actions carry weight. History matters. And when the judge speaks, the consequences are real. This entire proceeding becomes a powerful example of how the justice system handles individuals who stand at a crossroads, those who can either continue down the same path or finally choose something different. Whether they take that opportunity remains to be seen. But for now, Judge Boyd has made one thing clear: responsibility cannot be avoided, and the courtroom is where reality catches up.